Hi, I'm Melanie with the League of Women Voters of Kansas City.
In the upcoming general election in November, voters will be selecting their U.S. and Missouri state senators and representatives. In addition, voters will face 6 ballot questions. 5 will amend the Missouri Constitution, 1 will amend a statute. So why is this process important to us as voters? We all want to say in our government, many believe it is our right and our duty to actively participate in our democracy. We want our voices heard. Ballot measures give Missouri voters the opportunity and power to directly decide on matters that affect their daily lives. Because whether ballot measures come from the legislature or through a citizen's initiative, the final decision on the measure is reserved specifically to the voters. Not all citizens can independently change their state constitutions. Missouri is only one of 26 states where citizens can do so. Our current Constitution was written in 1945 and has been amended 119 times. Both citizens and the legislature can propose constitutional amendments. Citizens can attempt to change the Constitution by submitting an initiative petition. The legislature can propose an amendment through a process similar to passing new bills. Voters will see measures from both on the November ballot. We are going to explain each type of amendment path and tell you about the proposals under each path you will vote on in November. An initiative petition can be started by a citizen or an organization. If a sufficient number of signatures is gathered, the proposed amendment is placed on the statewide ballot for voter approval. Amendment 3, concerning reproductive health care, is an example of a citizen's initiative petition that will be on the November ballot. How can you get a constitutional amendment on the ballot? Has anyone been asked to sign a petition before you go into the grocery store? There are 4 main steps to a citizen initiative getting on the ballot. Step 1, a citizen or an organization starts the process by submitting an initiative petition to the Secretary of State's office. The Secretary of State's office approves the petition form and prepares official ballot summary language. The state auditor prepares a fiscal note summary. Then the Secretary of State certifies the official ballot title, which consists of the ballot and fiscal note summaries. The official ballot title must follow the single subject rule and use fair ballot language. What is the single subject rule? The Missouri Constitution restricts ballot measures to one subject and one article of the Constitution. For example, each of the ballot measures before the voters this November deals with only one subject. The sports betting amendment could not have included a proposal on the minimum wage. Fair ballot language is written by the Missouri Secretary of State as defined by Missouri law. To be fair, the language has to be a true and impartial statement of the effect of a yes or a no vote, not intentionally argumentative, not likely to bias the voter for or against the proposed measure, and state whether the measure will increase, decrease, or have no impact on taxes. Once the petition has been approved by the Secretary of State, the second step is to gather signatures. Current law requires getting an amount of signatures equal to 8% of legal voters for constitutional amendments and 5% for statute changes in 6 of the 8 Missouri congressional districts. The third step is to submit the signed petition to the Secretary of State no later than 6 months before the election. In our reproductive rights example, the deadline was May 8th. On May 8th, the sponsors delivered a petition to the Secretary of State with a total of 385,000 signatures versus the approximately 170,000 needed. The fourth step is for the Secretary of State and local election authorities to verify signatures. Local election authorities verify that signatures on petitions match the signatures on voter registrations on file. Around the last Tuesday of July, the Secretary of State announces the findings of the verification effort. The petitioner is notified if the Secretary determines that an insufficient number of signatures has been submitted. Any citizen can appeal that finding, with resolution of that appeal required within 10 days. If the Secretary of State determines that a sufficient number of valid signatures has been submitted, the petition is certified and placed on the ballot. Once on the ballot, a simple majority of votes is needed for passage. It isn't easy getting a citizen initiative before the voters. Between 2010 and 2020, less than 4% of the ballot initiatives that were filed by citizens were certified by the Secretary of State's office. However, once certified, the odds of passage improve. In the last 50 years, 66% of the certified ballot initiatives were approved. For example, in 2022, a ranked choice voting initiative petition failed to get the required number of signatures, while the recreational marijuana initiative was certified only on appeal. In each of the last 3 years, the legislature has proposed measures to restrict the initiative process. In 2024, proposals would have required approval by both a majority of voters and a majority in 5 of 8 congressional districts. These measures did not pass, but will likely reappear in the 2025 legislative session. Of note, the proposed legislation would not have made it more difficult for proposed amendments written by the legislature. It would not have added the requirement of approval in at least 5 of 8 congressional districts. Our state is comprised of 8 congressional districts, each with approximately the same number of people. Notice the difference in geographic size between urban districts 5 or 1 and rural districts 6 or 8. Those opposed to adding a requirement of passage by a majority of voters in 5 of 8 districts point to how this requirement would dilute the weight of voters in densely populated areas. Why do some people want to make the process more difficult? Those in favor of making the process more difficult say that the current threshold is too low. It is used to advance legislation that the legislature opposes, and interests from outside of Missouri have used the initiative process. What about people who are against making the initiative process more difficult? What is their position? They say the citizen initiative process has served different parties over the years. Increased requirements would make the effort nearly impossible for most groups to achieve, and as a result, the voice and will of the people in a democracy would be silenced. And it is easier for the legislature to advance constitutional amendments. Missouri is not alone in seeing attempts to restrict the citizen initiative. 26 states have seen laws advanced to do so. Most recently, proposals by the South Dakota and Ohio legislatures to restrict the initiative process were rejected by voters.
Thank you for taking the time to become an informed voter.